The views expressed on this show by guests and the host on issues outside of the 9/11 controlled demolition evidence are the opinions of those individuals alone and do not necessarily reflect those of architects and engineers for 9/11 Truth.
Welcome, everybody, to 9/11 Freefall. I am the host, Andy Steele, and this is going to be a big broadcast tonight. We are going to the Supreme Court. We're going to be filing a petition with them in our case against NIST. We're going to be filling in all the details, and I know our supporters are going to have a lot of questions. So let's just go ahead and jump right into it with our three guests. The first one is Roland Angle. Roland is the chairman of AE911Truth. He graduated from the University of California, Berkeley, with a Bachelor of Science in Civil Engineering. He served in the U.S. Army Special Forces, where he was trained in the use of explosives, and he became a licensed civil engineer in California. His 50 years of engineering experience has included designing and testing blast-hardened missile launch facilities and designing U.S. naval explosive containers, as well as harbor terminal facilities, earth foundation systems, and hydraulic systems. He is going to be joined by Mick Harrison. Mick is the litigation director for the Lawyers Committee for 9/11 Inquiry. His practice has involved extensive federal district court and federal appeals work, as well as extensive discovery and motions practice and litigation of virtually every conceivable technical and procedural defense used by agencies and corporations. It's also involved frequent examination of both friendly and hostile witnesses on technical matters, including complex mathematical risk assessments. And they are joined by John Clifford, and John he received his Bachelor of Arts degree from Michigan State University and his JD degree from the Catholic University of American Columbus School of Law, where he served as a member of Catholic University Law Review and as a Student Bar Association delegate to the ABA convention. He has tried more than 125 jury cases and hundreds of bench trials and has argued numerous appeals. So, gentlemen, welcome to 9/11 Freefall.
Thank you, Andy.
Thanks, Andy.
All right, so this is a big one, and I'm not even sure any 9/11 Truth group has ever gotten this far in the legal process. I'll be asking Mick. He will know more than I about that. But we're always taking on newcomers, new people interested in this issue. This could be the very first episode that they have watched about this matter. So, Roland, as the chairman of AE911Truth, can you just briefly remind our audience what has led us up to this point we're at right now in the legal process and what our suit against NIST was about?
The report that the National Institute of Standards and Technology issued on the collapse of the Twin Towers and the separate report that they released on the collapse of Building 7 were deeply flawed reports. When we looked into the information that was contained in those reports, we found numerous errors and inconsistencies and omissions and outright falsehoods that make the reports essentially invalid. So we went to NIST and on Building 7 first, and we asked them to please revise their reports according to our differences with them. And this is a normal procedure in engineering. If there are differences of opinion over a particular catastrophe or disaster and different opinions weigh in, then there's a back and forth that goes on. And through that process, you come to a conclusion. It's inescapable. Two different versions of the same event can't both be correct. So we filed a request for correction with NIST, and essentially they put us off for as long as they could. And when they did respond, after we pressured them, they essentially came back simply reaffirming their original content and refusing to engage with the information that we presented them. So we then filed an appeal, and the appeal went through the process, the bureaucratic process, and they were asked to reevaluate it. They reevaluated, they came back with the same reply. So at that point, we engaged the services of Mick and the Lawyers Committee for 911 Truth, and we had them perform a complaint, which went in front of the district court in the District of Columbia, and their ruling came down saying that we did not have standing. So I'll let Mick and John take it over from there, from the legal aspect. But essentially, we're here because we've got no satisfaction, no reasonable reply from the government and the agency that they put in charge of this investigation, and they're simply not responding. And I think they're relying on the courts to prevent them from having to respond. And from the response of the courts, I would say that so far that's been a pretty good guess on their part. But I'll hand this over to Mick at this point.
Yeah. And Mick, please comment on the process so far, because you were on the show only a few weeks ago, and we did not know how long this was going to take on the last filing. But here you are just a couple of weeks later, and we're talking about this next step going to the Supreme Court. But please fill our audience in on what that was all about and what happened with the last filing.
Okay, so I did consult with architects and engineers in the formative stages of their petition to NIST, and I will compliment architects and engineers. I think Roland's being a little modest in the sense that I thought architects and engineers did an excellent job of laying out the technical case for what NIST did wrong in its Building 7 report, and made a really meticulous, scientifically meticulous argument for why the Building 7 report had to be corrected by NIST, and that NIST's conclusion that Building 7 collapsed due to fires alone, not having been hit by an airplane, but just fires started by some rubble from the towers that fell on Building 7, well, that couldn't possibly be true from an engineering, architectural, or scientific perspective. So I was impressed with the scientific case that architects and engineers made. I was dismayed that NIST did not give more attention to the details of those arguments that AE presented to them. So I was more dismayed when the district court, as Roland properly points out, denied our lawsuit against NIST under the Information Quality Act for its denial of AE's petition. I was dismayed that the district court decided that none of the parties had standing. And it wasn't just architects and engineers that brought that lawsuit. It was architects and engineers and friends. And those friends included several members of victims of 9/11, members of the families, and also several architects and engineers. And the court decided that none of those folks had standing, including architects and engineers. So we appealed that decision to the U.S. Court of Appeals for the District of Columbia Circuit not too long ago. I remember the date. August, maybe. Probably won't remember the exact date. We got a decision that was adverse. The Court of Appeals affirmed the district court on standing, deciding erroneously, in my view, that none of our plaintiffs had standing again. So that is what brought us to bring the last thing that we talked about, Andy and I, on the last program, which was the petition to have the Court of Appeals reconsider en banc, which means every judge in the circuit. And that petition was denied December 6th, I believe, which brings us to today and why we're talking about going to the next step, which is the U.S. Supreme Court.
Absolutely. And this is the appropriate stage or the appropriate step at this time, because I believe there is nowhere else to go right now. And so we're going to go there. Now, before we continue on and get into the details of what this is going to involve, I want to introduce our audience to John Clifford. I'm actually meeting you for the first time right here on the show. So please briefly tell us about your background and how you were drawn into this case.
Oh, check your audio, John.
Oh, you're muted. There you go.
There you go.
My background is as a trial lawyer in the District of Columbia for almost 50 years. And in that time, I've done all manner of things. A lot of employment laws, it turned out, but a lot of other things. I've litigated pretty complex medical malpractice cases here and in Boston, Massachusetts. I've done whistleblower law in here and in other parts of the country, and I like trying cases. I like litigating, and I like trying to figure out the truth of the matter. Mick and I met in the course of handling a case involving care of children by the District of Columbia, and we worked well together. And the case had nothing to do with employment, had nothing to do with medical malpractice. And it was an area that I had never done anything in before, but we managed to figure it out and make it work. So we liked working together, and he asked me if I'd be willing to assist, and I reviewed the matter and happy to assist. That's about it.
What attracts you most about this case that you're going to get involved with now at this level?
Well, first of all, Mick will do most of the work. That attracts me a lot. Mick's a very good researcher and writer, and it's a pleasure to add my name to his work. But it's a puzzle that's difficult, and I think that we can see that something's just not true here, and I think trying to get that fixed is what makes the case attractive.
Absolutely. And there's some major implications wrapped up in this that goes beyond 9/11 Truth. I'm going to turn it over to Roland for a second because, we talked about this pretty in depth when it was just me and Mick on the show. But as chairman of AE911Truth, and of course, as an engineer, I want to get your perspective on this. The fact that the lower court's rulings essentially said that as long as the federal government meets statutory requirements, they don't have to be scientifically accurate in their reports that they issue. I shouldn't have to point out that is really messed up, and to put it in layman's terms, from the American taxpayer's perspective, American citizens' perspective. As an engineer and somebody who has been involved in that profession for so long, what are your thoughts on those sentiments from the courts that the reports don't need to be scientifically accurate unless Congress explicitly states it?
There's two problems here. The first problem is, as a profession, any profession, and we're talking about the engineering profession here, if false information is allowed to enter the discourse and find a place within the information that profession relies on, it begins to spread like a cancer and undermines the credibility of the profession and the trust that the general public has in that profession. And that's a real problem. So our first position is that we are defending the reputation of our profession. We are, in fact, legally obligated by our contract with the state, if we're licensed by the state, which we are, part of that contract is that you must be faithful to the practice and the experience of your profession. And if you see something that is not in accordance with that practice and with that experience, then you are duty bound to report it and try to correct it, because the obligations of your profession are such that you have a duty to the public. I know that most of us, we don't think about the things that go into engineering when we go about our daily affairs, but when we go to buildings, when we ride on highways, when we fly in airplanes, when we do any of the really wonderful things that engineering has accomplished in this society, we don't tend to think about them very much anymore. But imagine if there's some error, and sometimes there are errors that creep into the profession, and the result is a catastrophe. An airplane crash, a dam failure, an explosion. These cost lives, they cost money, and they call into question the competency of the engineering staff that performed that work. So on 9/11, you had 2 airplanes crash into these towers, and shortly thereafter, the towers collapsed to the ground in dramatic form at almost free fall speed. And when you look into the background, you see that the towers were in fact designed to withstand the impact of commercial jetliners, because there had been an airplane crash into the Empire State Building back in the 40s, and the proximity of these high-rise skyscrapers to the nearby airports led to the conclusion and the obvious problem that perhaps this was going to happen again. And so that became part of the design standards that the structural engineers put into the towers. So in engineering, if you design something to withstand a particular event, and that event occurs, and the design does not withstand the event, then you have a problem. You have designed something to withstand a particular event, and it did not do so. What went wrong? So this opens up the whole field into a debate as to what happened, what was wrong. Now, in the case of these, in the case of these 2 towers, you had a theory that was put forward by a professor at Northwestern University, Professor Zdeněk Bazant. 2 days later, he submitted what he considered to be the problem to a major engineering journal, the Journal of Engineering Mechanics, an ASCE publication, long-standing tradition, well thought of. And he put forward this theory that the planes had weakened the section of the building that they hit to the extent that the top portion of the building fell on the lower portion of the building and crushed it all the way to the ground. And he had a theory and mathematical models that he presented in his paper. Well, when we looked at those mathematical models, we found that there were errors in them. And so we pointed those errors out. He has defended that theory in spite of our argument with him. And he's essentially, and the ASCE has essentially cut off all debate. They won't answer our queries anymore. And this is a problem, because this is in absolute contradiction to the whole history and practice of engineering and scientific inquiry in general. You don't just cut off debate because you don't agree with somebody. You have to explain why you don't agree and back up your arguments with scientific and mathematical proof. They're not doing that. So that's the problem. We have a problem. That's the problem within our profession. The broader problem, of course, this event caused major historical events. It caused wars. It caused many deaths in many different countries as a result of the policies that the U.S. government established based upon the NIST reports and the notion that these planes had caused the buildings to collapse. Building 7, of course, became another matter because it collapsed later that day, wasn't even hit by a plane. That had never happened. So that presented another problem for us. We've been attempting to get an answer that makes sense to these problems from the government and from the contractors that they hired, and we've been unsuccessful. They have called us conspiracy theorists. They've called us lay critics. They've called us outside influences. We represent over 3,500 architects and engineers who are licensed by their states, and in some cases, many states, to present this information in a professional and technical manner. It's accepted by the profession. So we know that because they resorted to these essentially ad hominem attacks upon us, that they don't really have any answers. And that tells us that we're right. And so that's
I just
what
want
we have today.
Yeah, and I just want to add in, too, as we said when Mick was on the show a few weeks ago, they haven't even taken us on the facts or on the science. What they have done is they have hidden behind this argument that unless Congress explicitly states that the report has to be accurate, all right, that should go without saying. Most people, John Q. Public assumes that if you, that you can fight City Hall if you got your facts straight and can show that you're right? But the government has said now that they do not have to be accurate in the reports unless Congress explicitly states that. This has major implications, not just for 9/11, but for any issue in which science sits at the center. They're saying that the government can essentially lie to you. And so, we can go through the entire Building 7 report, point out what they got wrong, and it's not just like some minor thing here or there. They ignored observable facts when putting this report together, and they say, hey, you know what? As long as we wrote a report, we're fine. That's it. I'm sorry. That is a major constitutional issue in my view. John, just before we start talking about the process of the Supreme Court with Mick here, what do you think about these rulings that you've seen so far and catching up with this entire process here? What do you think about those sentiments that government does not have to be accurate in scientific reports?
It's enough to make you cry. They should be ashamed to say that. And I'm ashamed that the government does say that. And that's about it. It's just a terrible thing. And I believe in science, and I believe in truth telling. This is saying you don't have to worry about truth telling. You can ignore science. So that's what I think.
Yeah, and sometimes it can get so ridiculous that you don't even know what to say at that point. And some people get apathetic. Some people just laugh at it. I've seen this in other countries where there's open and outright dictatorships running things. They'll laugh about the tyranny. But in this case, where the government is allowed to lie to you, I refuse to start laughing and see it as funny or to get apathetic about it. Somebody needs to get outraged, so we're going to do it, not just on behalf of the 9/11 issue, but on behalf of the entire country and whatever future issues are going to be debated in which science is at the core of it. So hence why we are doing this. We are at this unique opportunity. We've been presented with it to take this to the U.S. Supreme Court and really try out this ruling, see if the Supreme Court will have the guts to back it. So Mick, give us an overview on this process. Why is it basically talk about filing the petition first, and then I'm going to have a lot of questions about the Supreme Court process, but talk about the process of filing it and what we can expect from an operational perspective in the next few weeks.
So the petition to the U.S. Supreme Court is a two-stage process. The first stage is controlled by Rule 10. I'm actually showing you Rule 10. Andy may be able to help you see Rule 10
let
on
me
your
get
screen.
that up on the screen here. 1 second. There we go.
Okay. So in Rule 10, the court is advising the public, folks like us who are considering going to the Supreme Court, what are the reasons they might consider important enough to grant your petition. And that's what Rule 10 is about. And they give some examples, which are not meant to be exhaustive, of reasons that would be sufficient for the highest court in the country to take on your case. And one of those is that the U.S. Court of Appeals has entered a decision in conflict with the decision of another U.S. Court of Appeals on an important matter, or has decided an important federal question in a way that conflicts with the decision by a state court of last resort, which does not apply to us, the first one does, or has so far departed from what's called the accepted and usual course of judicial proceedings, or sanctions such a departure by a lower court as to call for an exercise of the Supreme Court's what we call supervisory power. That means the Supreme Court is supposed to keep the lower courts in line and maintain some uniformity in the law being applied nationwide. One of the things that Roland was talking about, and John commented on, and you did, Andy, fits into this last rule about something, an issue so important, or that a court decision so far departs from usual and accepted procedure as to warrant intervention by the Supreme Court. What we've been talking about here is the Court of Appeals in D.C., Federal Court of Appeals, saying it's okay if NIST issues a false report, even if they knew it was false, about why Building 7 collapsed, even though the implications of that collapse are huge in a number of ways, including for the reasons Roland has explained. But the significance of that decision by the Court of Appeals, that it doesn't matter whether an agency lies to the public, in this case lies to Congress, in response to a congressional mandate, because the report they issued, that NIST issued, was required by Congress under the National Construction Safety Team Act. So it was a report required by law, and the court said yes, and the court acknowledged that we were right, that it was a report required by law and that it had to be issued to the public. But the Court of Appeals said it doesn't matter whether we're right that it's false or not, or even knowingly false or fraudulent. They issued a report, that's all that's required of them, which is getting to the point Andy was talking about, that it's okay to disregard science and truth. It's okay for an agency to disregard science and truth. Well, that's not the law, and it never has been the law. I mean, that's why we have an Administrative Procedures Act, a statute that Congress passed years ago that says you can ask a court to strike down an agency action if it's arbitrary and capricious or contrary to law. Well, knowingly issuing a fraudulent report is essentially, by definition, arbitrary and capricious. So we want to use this petition option in Rule 10. And just for those who don't know, this is a discretionary option, which means the U.S. Supreme Court does not have to hear our case. It's going to review our petition, decide whether our case is important enough, and decide whether it will take this case as the 1 in 100 or 1 in 1,000 that it will hear, and decide on the merits. And the U.S. Supreme Court doesn't take a high percentage of cases that come to it, and a lot of cases do come to it. So we have a bit of an uphill battle here, but here's the gist of why this case is important enough for the highest court to hear. I agree with Roland that it undermines the integrity of the engineering profession, and it also undermines the integrity of the government to allow NIST to engage in conduct like this and get by with it. But it's worse than that, because this rule of law that the D.C. Circuit has established, and it is a new rule. In my view, it's never existed, to say that an agency can just thumb its nose at Congress and issue a knowingly fraudulent report that's required by Congress to be issued, and that's okay. So what does that mean about areas beyond engineering? What if the Department of Homeland Security or FEMA or Health and Human Services issued a blatantly false, knowingly false report on either the last pandemic or the next pandemic? What if the Department of Defense issued a knowingly false report about circumstances that led us into the last war, leads us into the next war? We could go down the list. The United States, is, how shall I say, government dependent in many ways. The people of the United States don't have the resources to do a study like NIST did, which cost millions of dollars. They don't have the resources to do that for themselves. Architects and engineers, to its credit, had University of Alaska do a study, which was quite impressive, and spent a few $100,000 on it. But the people rely on the government to tell them the truth in many areas that are critical to our survival. Climate change comes to mind as another one. So the principle of law that we want the Supreme Court to hear in this case is critically important, because if the Supreme Court doesn't correct the path that the DC Circuit has mistakenly chosen to follow, then, this country, which depends in large part on the integrity of its administrative agencies and the accuracy of their tax-funded reports, is going to be in dire straits on a number of issues. And we're facing a number of serious issues these days, not just the 9/11 issue and issues that relate to it, but a number of other issues that are potentially existential. Climate change and pandemics come to mind. So what we're going to do, Andy, is we're going to file the first stage petition, which is called a petition for certiorari, explain the importance of the matter to the U.S. Supreme Court, and we may invite some other organizations to join us as friends of the court, because it is an issue that cuts across many areas of concern by a number of nonprofits, for example. And if we win the first phase, which is get our petition granted, that's not the end of the matter. There is the second phase. If we win the first phase and our petition is granted for certiorari, all that means is, but it's an important step, that the highest court has decided to hear our case and decided on its merits. And that then would require a second round of briefing, more detailed on the legal issues and the facts on the merits. And we would win or lose on the standing question at that point. At that point, we would get into the ins and outs of why the court was wrong to say that architects and engineers, 9/11 family members, and the actual individual architects and engineers did or did not have standing, and the court below decided did not have standing to bring this case. So the mistakes that NIST made, which may not have been mistakes, may have been knowing misrepresentations, have not yet been corrected, and the court below did not get to the merits. And what we want to establish, to achieve for the first time in history, is to get a decision from the highest court to have the Court of Appeals remand the case back to the district court to essentially have a trial so we can prove up the allegations of what NIST did wrong regarding why Building 7 collapsed. This may be the first time, I believe it's the first time, when a citizens group has brought a 9/11 related case to the U.S. Supreme Court, and it will have huge implications if we win it.
Well, yeah, absolutely. And we're going to get into that because I have some questions as well. But who's going to be deciding during these steps? Like, we know there's 9 Supreme Court justices. I believe there's 9. But, who decides that it gets onto their desk? Like, who are you appealing to first at the Supreme Court?
Well, the justices all review the petitions that come to them, and they all vote on which of the petitions to accept or reject. So you're really talking about the justices on the highest court making this decision themselves. Now, they have law clerks who they've hired to help them with their task, and they will probably assign certain homework to those clerks. But ultimately, the vote about whether to take AE's case or the other cases that are be coming in to compete is going to be up to the individual justices. And if a majority vote to take AE's case, it will be heard.
Now, how much time do you have to prepare at each of these steps that you just outlined? Is it something that's going to move rapid fire, or will you have some time to get yourselves ready?
Well, we do have some time, thankfully. The petition is due around March the 6th. It's 90 days from the decision from the Court of Appeals denying our rehearing petition. So we do have some time to do a good job on it, and also to inquire whether we might have some other organizations support us. And any other nonprofits watching this program, I would encourage you to consider having your organization file a friend of the court brief, because to adopt a rule of law that it's okay for a federal agency to knowingly lie to Congress and the public on a matter of great importance is going to be a huge problem across the board for nonprofits. It's not just AE that's going to have a problem with that. So we do have time to prepare. Now, once the court grants the petition, which we hope it will, there'll be another probably few months process. The court will direct the parties to file a round of briefs on the merits. And normally, after those briefs are filed, the court entertains in-person argument from counsel from all sides, and sometimes from the amicus, the friends of the court. And there should be sufficient time to do a good job on that brief as well.
Now, I remember in Bush versus Gore, they played some audio from that case on television, which is rare. They don't do that a lot. But that was a big matter concern for the country, and a lot of people were paying attention. But what really got me about it is when you watch most court cases, you're used to a certain kind of procedure and a certain way of things. But when you listen to Al Gore's lawyers talking with the justices, it seemed like a more conversational process. And the judges could interrupt them and ask specific questions. Is that an accurate description of the process if we get to this point, or not?
Pretty much. It's not like a trial where you're examining witnesses or putting on exhibits. It's an oral argument, the purpose of which is not to let the attorneys make their pre-prepared speeches, even though we all have a pre-prepared speech. The purpose is actually to let the judges ask counsel questions on unresolved matters in their minds so they can decide how to resolve the case. And they taught us in law school that even though your normal reaction to being interrupted in giving your wonderful speech you prepared is to be dismayed and to consider it to be rude, it's not actually rude. It's actually the court's job to do that. And it's your job as counsel to accept the interruption, and not just accept it, but to embrace it as an opportunity. And it's an opportunity to get a window into the minds of the justices to see what they're thinking about the case, which you don't have any other way to accomplish. And so you have to use that opportunity when they ask you a question to speak to what's on their mind, because that's how you're going to get a chance to influence the outcome in the case. So yes, that is the way it goes. And you actually, as an attorney, should welcome those interruptions. They're much more important than letting you give a pre-prepared speech, because if you get an opportunity to hit on the one thing that matters to the justice, you might actually change their mind or confirm that they're already thinking in the right way.
Right. So as you go through after you go through all the procedures, it all comes down to a conversation with a group of people. I think that is fascinating. How it all boils down to that. Another question that I have, and I don't know a lot about the Supreme Court process, and I don't think a lot of our audience does either. We pay attention to the president, we pay attention to Congress, but rarely do we ever hear about what the Supreme Court is doing or pay a lot of attention unless it's a big case. We're the ones filing the appeal, of course, so our attorneys will be there. Are the government's lawyers also going to be there at the same time, and will they be given equal time? And is it a back and forth with them, or do you guys do it separately?
So it depends on the phase we're talking about. If we're in the first phase, where we're doing a petition for certiorari, there normally would not be oral argument at that phase. And the decision to grant a hearing on the case or not would be based on our petition, and it might be based on our petition alone. The government may file a response, and the court may invite or require the government to file a response. And if that happens, then the court would review both documents, ours and the government's, in deciding whether to grant certiorari, which means to hear the case on the merits. Once you get past that first phase, and there is a decision to hear the case on the merits, which means certiorari has been granted, at that point, both sets of attorneys, and usually more, meaning friends of the court and their attorneys, will be present, and all will be given a chance to argue. It varies case to case as to whether the friends of the court get to argue and whose time they end up sharing for that purpose. But yes, all sides of the argument normally would be, at least in the second phase, would be present and be given a fair chance to answer the court's questions.
Now, and John, feel free to jump in too if you want to on this question, but our supporters probably want to know, will this be strictly a constitutional debate, or would the World Trade Center evidence on Building 7 make its way into the Supreme Court and be argued? Would there be an argument about the evidence there, or is this all just about, that ruling and its implications on our system?
Well, let me start, and then we'll have John supplement. I'd be interested in John's views. There is a constitutional question, because folks may not realize standing itself is a constitutional question. It's based in the Article 3 of the Constitution, as I recall, the case or controversy requirement. And without getting into the ins and outs of standing in the moment, it basically has to do with whether the federal courts have the power to hear your case. Under the Constitution, they are limited, federal courts are limited to hearing cases or controversies, which the courts have read to mean both sides of the issue have to have a legitimate interest in the case enough to make them true adversaries. We do have an adversarial system of justice, for better or worse. The judges themselves don't take an active role in digging out the truth. They rely on the competing sides to put the competing evidence in front of the judge, and then the judge decides based on that what the truth is. So it's adversarial, and that system doesn't work if the parties are not truly adversarial. So you have to have parties who have a vested interest in the outcome and a different interest to have that adversarial scenario, and that's what standing is based in. So it is a constitutional-based question, but there are also issues in this case that are not strictly constitutional, although there is, I think, hiding under this sort of what I call a draconian view of the standing limitations, an underlying constitutional question of access to the courts and citizens' right of access to the courts. And that may be laid out in our petition. But there's also statutory questions. And then the additional sort of elephant in the room about the separation of powers and the idea that we have a check and balances system of government where the judiciary is supposed to oversee the executive branch and be a check on abuse of authority by the executive branch. And this ruling that we're getting from the DC Circuit is problematic in regard to that check and balance on agency abuse of authority, because, first of all, if nobody has standing to challenge an agency decision like the NIST fraudulent report, then the courts are not able to exercise their power to hold the agency accountable for following, for example, the statutory mandate from Congress in the National Construction Safety Team Act. It's pretty clear to me that when Congress passed that law, they didn't want a token, a negligent, and certainly not a fraudulent report on the reason why a building collapsed in a matter of public importance like the Trade Center collapses, where there was the potential for great loss of life. They wanted the real reason. They wanted a real scientifically valid analysis of the evidence. That's why they passed the law. And they wanted the public to be informed by that type of report. They didn't want the public to be misled by a false report. So how does the judiciary perform its check and balance role of holding NIST feet to the fire and force them to comply with the intent of Congress? Well, the answer is, if nobody has standing to bring the suit, the courts never get a chance to exercise their oversight authority. Because unlike Congress, who can do their own investigation on their own initiative, a court can't do that. A court requires parties to come to it with the controversy to exercise the court's oversight power. So when you limit standing, you limit the ability of the judiciary to oversee the executive branch. And that's the elephant in the room here. and in terms of the implications constitutionally with this type of standing restriction and why the case is important to hear. And then you have the issue of, well, what's the meaning of the Administrative Procedures Act, another longstanding established law that Congress enacted in order to hold agencies accountable. If an agency can issue a fraudulent report knowingly, what meaning does that Administrative Procedures Act standard about arbitrary and capricious agency action actually have? I'll stop there for the moment. There's a lot involved in this case that's of importance. John, do you have any observations on my ramblings?
No, I think you got it right, Mick. I don't have anything to add to that.
Okay.
All right. So let's say we win. Let's say we go through all of this process here and we win in the end. What then needs to happen on the government's end, and what would they be obligated to do?
Well, that's a very significant question and really shows, I think, to your audience why this next step is worthy of their support. I know you'll be asking them for their support, and I hope that they do give you their support, because the answer to this question explains why it's a very worthy cause. If we win the first phase, and by the way, even in the first phase, we'll be educating the highest court in the country on some key facts regarding the tragedy of 9/11 and the issue of the demolition evidence that many members of the Supreme Court may never have heard before. So that's the first thing that's going to happen. And the second thing is, we granted certiorari. We then get to do a second brief on the merits, where we get into more detail, including the merits of architects and engineers' petition to NIST, why AE was correct about the demolition evidence, why NIST is wrong about relying on fire as an excuse, and why they should know they're wrong. The science doesn't support that explanation. We get to educate the highest court in the country on the details of AE's petition and this whole demolition evidence debate, which really should not be a debate, not among engineers, architects, and scientists. So that's hugely important. And then if we win at that stage, and the court says, yes, you're right, and I think they should say this, that Congress intended this to issue a report in good faith, not a dishonest report, a report that has integrity, that's not a fraud, and we're alleging, architects and engineers, that they didn't do that. And to have informational standing, all we have to show on our interpretation of the statute is that the organization, architects and engineers, are adversely impacted in their mission by the false report. It's pretty clear they are already, because they spent hundreds of thousands of dollars to try to debate and rebut it. And the court could and should then say, okay, standing is present. The plaintiffs have standing. And so what does that mean? It means they have to remand the case. Supreme Court remands the case back to the Court of Appeals to remand the case back to the district court, which is the trial court. And at that level, we should be allowed, for the first time in history that I can tell, to present our evidence on the merits of AE's petition to NIST, which is the merits of the demolition of the World Trade Center buildings, particularly Building 7, on 9/11, and be able to prove up for the first time in history that AE is correct about that evidence. And if we get a chance to do that in a public, verified before a judge, that will have huge significance.
Absolutely. And they'll have to actually defend their reports, which they have not been able to do. They hide behind these arguments that we're going up against right now. Right. So what you're going to be doing is you're going to be tearing down this this big wall that they've built around themselves and leaving them there shivering and exposed, and their entire unscientific report exposed as well. And then we can swarm in and get some justice here and get these things corrected. Roland, I know that, when we talked about this, the board voted unanimously without much discussion or debate in favor of doing this, because they were so certain this is absolutely the right step to take. Why are you so certain this is the right step to take after listening to all the things that Mick and John have had to say?
Our entire system of government is based upon the three powers: the executive, the legislative, and the judicial. And as Mick has pointed out, the judicial is supposed to be the watchdog. Now, in this case, we're alleging that the executive branch essentially had a dog in the fight from the very beginning. Let's look at what happened. On 9/11, somehow our defenses were breached. Planes were hijacked, flown into buildings, thousands of people died. Our entire orientation of our society changed. We went to war. And we have to go back to the essential question: how did that happen? And the Department of Defense was an executive branch agency that was responsible for our safety that day. And somehow they failed. So the question is, well, what really happened? How did they fail? How did this all come about? So Congress, the legislative branch, passed a law and said, well, we're going to appoint NIST to investigate and see what happened and how those buildings came down, and we'll verify that the story that we're being told is accurate, that the executive branch is telling us that, well, the buildings failed because the planes ran into them. But what if that's not the story? Well, NIST is another arm of the executive branch of the government, just like the Department of Defense. So you have an immediate conflict of interest here. NIST should never have accepted the task of investigating the cause of the building failures, because they're both, NIST and the Department of Defense are arms of the executive government, executive branch. So you can't have one of the suspects in what happened involved in the investigation, because there's going to be a bias there, isn't there? Everybody understands that. You're not going to have somebody involved in the investigation that could possibly have had some culpability for what happened. And NIST, let's look at the example of airplane disasters. The National Transportation Safety Board is the agency that investigates airplane crashes and disasters. They are a separate organization, and they are not connected directly with the executive branch of the government. There's an attempt there to put a firewall between them and the executive branch of the government, because the Federal Aviation Administration is responsible for control of air traffic in this country. So what happens if the FAA made an error and was somehow involved in this crash, or made a mistake that was part of the reason why the crash occurred? So the FAA doesn't investigate crashes, and no other executive arm of the government investigates airplane crashes. The National Transportation Safety Board is supposed to be insulated from those influences. And that all came about actually through a historical event, the crash of an airliner in 1931 that had a very famous person on board, Newt Rockne, who was the coach of the Notre Dame football team, was a very beloved figure in American sports. He was on a plane that crashed in Kansas, and the precursor to the FAA conducted an investigation, and it found out that it was revealed that they had not properly controlled the manufacture of that plane, because it was put together with glue that fell apart when it went through a rainstorm. It was water-soluble glue. plane fell apart and crashed. FAA was the precursor to the FAA, which I forget their initials at this point, but this was before the FAA was formed. The airline industry was just in its infancy. Point is that when they investigated their own crash, they had a hard time admitting that they were at fault. Same thing is going to happen here. NIST, the executive director of NIST, should have refused to take on the task of investigating this crash and this event because there was an inherent conflict of interest. So that should never have happened. So that's right at the beginning of the process, and I would assert that that's the reason why we have the problem with NIST right now, because NIST is subject to political pressure. They're an arm of the Department of Commerce, and in fact, they have a poor record themselves. I could go into that, but I'm not going to waste our time talking about that. But there is a history there of NIST being hijacked, pardon the pun, for political purposes, and I think that they were selected and they were brought into this investigation precisely for the reasons which we see that have occurred since. So it's a political issue. It was a political question. You can see that the reaction of the government was political. We went to war.
And you're going to have some debunker out there and say, well, who do you want to investigate it then? Well, the issue is, though, regardless of who at the government investigates it, is that when you have incorrect information that's pointed out by John Q. Public, but not just anybody, by at least 3,500 architects and engineers, the government is under an obligation to correct that error, to give us correct reports. So even if you don't like what we're saying about September 11th, listening to this right now, do you care about kids being affected by toxic chemicals in your local community and getting cancer from it? Because a scenario could happen where a company is doing this, and let's say the CEO is best buddies with whoever happens to be president at that point, and the federal government puts out a false report saying, oh, don't worry, those chemicals are just fine. I don't know why all these people are getting cancer, but the chemicals are just fine. Here's some pseudoscience to back it up. And if you're against us on this case that we're taking to the Supreme Court, then you're all for the government being able to do that. So even if you're against us on 9/11, forget about that. Do you care about scientific integrity? Do you care about being able to trust at least something, science, coming from your federal government? Because one thing does affect the other, and it's that scenario that I just laid out for you that we are fighting for. We want to protect the integrity of science and be able to trust our government again and be able to correct them if they put out something that is just knowingly false. We are at the end of the hour, but Mick, I'm going to give you the final thought on this matter. Your thoughts on my sentiments there, and what would you like to leave our audience with?
Well, the law provides a solution to the dilemma that Roland is pointing out about what happens when the executive branch has improper motives or a conflict of interest and an agency does something wrong, in this case, knowingly wrong. Who do you get to investigate it? And you could, of course, try to do an independent commission like they did originally on 9/11 without great success, or the second 9/11 commission, which a lot of folks don't even know about, which we sued on with the Lawyers Committee, which was even less success. But the law provides a better solution, and that is an adversarial litigation where the citizens impacted can actually put their evidence in front of an independent judge using the power of discovery, the power of cross-examination, the power of subpoena, and allow the judicial process, which is adversarial, to run its course and have the truth decided by an independent judiciary, which is what the founders intended with judicial oversight of agency misconduct. The founders anticipated that agencies would be allowed to be hauled into court and held to account before an impartial judiciary, and the victims of the misconduct could make their case to a judge. Now, we're being prevented from doing that in the first instance by the standing ruling, which is erroneous in my view. It's an improper interpretation of the standing requirement. The founding fathers and mothers, in my view, never had this anticipation that it would be this hard for a citizen to get their day in court, or this hard to get judicial oversight of the administrative branch, the executive branch. So, this whole, I would call it abuse of the standing doctrine. There was an editorial in the New York Times some time back which called it the weaponization of standing, that this is essentially undercuts the separation of powers, undercuts judicial oversight, and prevents access to the courts that the Constitution requires. So there's an easy fix to this, and that is the Supreme Court can grant our petition, send this back to let AE get its day in court, to let the family members get their day in court, and prove up their allegations. What's the worst that can happen? If we're wrong, we won't be able to prove it up. And if we're right, everybody needs to know it, particularly the executive branch and the Congress. And I will say that AE did a remarkable job of laying out their scientific case very meticulously. If we get that day in court, we're going to be able to make that case.
Absolutely. AE911Truth is in a rare position to be able to mount this challenge because of you out there in the audience, our great supporter base, and it's an expensive process, but we have to do this. We have to test the Constitution of the United States, and of course for the World Trade Center issue as well. But we need to protect the integrity of the government, basically, in putting out these scientific reports. So we're going to seize on this opportunity. We need your support to be able to make this happen. Please consider donating if you have not yet. And we're gonna test our Constitution with this by going to the Supreme Court. Guys, thank you so much for taking this up and for standing with us every step of the way. And we're going to keep our audience informed of every single development. But thanks for coming on 911 Freefall today.
Thank you, Andy.
Thanks, Andy. Thanks for having us.
Thanks for letting me join in.